Okay, it's Josh Borman here from Borman Lawyers. I've just appeared at the Newcastle District Court today. That's the courthouse behind me. So the reason why I appeared at the District Court today was because I was contacted recently by my client who had a low-range drink driving matter. He appeared with another solicitor at the Toronto local court. Obviously, that's in the region sort of around Newcastle and north of Sydney. So he appeared there. His blood alcohol reading was 0.074, first offence for him. He has a clean traffic record, a clean criminal record. He is an Indian national and he's originally from India. He's been here for about 7 years. He's on a working visa. And on the night of the offence, he had finished work. He works at an Indian restaurant in the Newcastle CBD. He'd driven home at about 10:30. He'd got home. He had a couple of beers to unwind. He hadn't eaten all day, and then made the very foolish decision to get in the car and drive down to the local 7-Eleven to pick up some late night snacks. He was pulled over for a random breath test. Nothing aggravated about his manner of driving. He was the sole occupant of the vehicle. It was late at night. There was minimal traffic around. So there was nothing aggravated about this matter, but obviously 0.074 was the reading. He did the traffic offenders program, got some good references, including one from his employer. Went along to the Toronto local court with another solicitor, but unfortunately he didn't get the outcome that he desired. He was disqualified for 3 months. He was given a $600 fine and he received a criminal conviction. So his previous solicitor correctly advised our client that he could appeal the decision, take it to the district court, and there's nothing to knock anything that the previous solicitor did wrong in any way. Sometimes you can take a low range or a mid range or a PCA matter which you think you're going to get a no conviction for, and it just doesn't roll that way. Obviously at the end of the day it's the court's decision, and it didn't fall on the side of my client at the local court at Toronto from my client. So he was rightly advised that he could appeal the decision. He filed the severity appeal. He then contacted me because I'd actually represented one of his friends previously and got a good outcome for them. And we started preparing for the appeal, which was before court today. So obviously all the letters, the traffic offender program certificate, all the material that was tendered at the local court was still on file for this appeal at the district court. But we did go and prepare some additional material to help his case. We got another letter of support from his employer, which went into a bit more detail about his crucial need to be able to drive to perform his job and also to get home each night and the times that he finishes. I went and did some research on the local public transport timetable and did a bit of a 7-day snapshot of each day and the times that the buses finish. And they usually finish at about 8:30 at night. He finishes work each day at 10:30 p.m. and there's simply no public transport for him to commute home. Additionally, without a license, he'd be unable to do any of the food delivery services for the restaurant that he works for. So he'd effectively be put into a situation where he would not be able to work. He's got significant debts, and we presented all that material before the court. And including the public transport timetable and a Google Map printout just to show where he lives and where he works, the updated letter from his employer. So this was all well received, and we presented the matter before His Honour today, who took into account the low level of objective seriousness the relatively low blood alcohol reading. In fact, there was nothing significantly aggravated. The good traffic or the clean traffic and criminal record that he presents with, coupled with his very strong subjective issues and his need to be able to drive in order to earn an income and prevent himself from going into severe financial hardship. So all these issues were received well today, and His Honour did decide to allow the appeal, which was really good, and he quashed the conviction and ordered that our client enter into a conditional release order for a period of 12 months. So that effectively means he can continue driving. He won't lose his license at all over this matter. His fine, he doesn't receive a fine for the matter, and no criminal conviction will be recorded. So an absolutely outstanding outcome. He does have to go on to a good behaviour bond for 12 months, but given his clean record, I think he will breeze through that period of time. He's a very relieved client today, and we're happy to assist him here at Newcastle District Court. Thanks for tuning in. I want to thank you for tuning into Borman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel, because we've always got fresh new content coming through all the time.